Mandated reporters may have interactions with children that occur in a virtual environment. Their responsibilities as a mandated reporter remain the same. When assessing safety virtually, whenever possible, be alert for indications that a child is trying to communicate something to you without someone else in the room noticing. Note if the child's demeanor or behavior is different when someone else enters the room. Listen for concerning statements that a child makes to you, siblings, or their peers. You may observe or hear an altercation between children or adults. If what you hear or observe does not rise to a level of making a report, it still may create an opportunity for conversation about safety or managing stress. Try to observe the child's body, even if you can only see the child's face, neck, shoulders, and chest. Is there anything that seems suspicious? Does the child appear depressed or anxious? Also, be sure to use reliable technology with adequate lighting and sound. Make sure the child is present for at least part of the visit. Make sure to have everyone introduced that is in the room with the child or who enters the room after the visit starts. Ask if there is enough privacy for the child and or parents to discuss sensitive matters. This may mean asking non-participating household members to move to a different room. Confirm their physical location in the event you need to contact emergency services. Watch carefully. Verbalize what you think you are seeing and ask if the family agrees. Also, be sure to provide clear channels to reach out. This can be done by email, phone, chat, text, or any online tool. Pay attention to nonverbal cues. Note if a child's demeanor or behavior is different when someone else enters the room. Be alert if a child turns off a webcam or is very hesitant to use one. Look at the environment. Are there any noticeable unsafe conditions present? Is there appropriate supervision for the child? Are young children watching, even younger children? Poor school attendance, in and of itself, does not equate to a reasonable cause to suspect maltreatment. A report of suspected educational neglect should be called into the SCR as a remedy for excessive absences, only as a last resort. First, try working with the student, family, and community agencies to identify needs and resources available to meet those needs. All of the following elements must be present to warrant a call to the SCR for educational neglect. The child must be of compulsory school age and currently living in New York State. The child must be excessively absent without a valid reason or excuse. The child's education must be impaired due to excessive absenteeism, or the child has an IEP and has missed necessary services due to excessive absenteeism. The parent or the person legally responsible has been made aware of excessive absenteeism and impairment by means simply beyond sending a note home or leaving a voicemail message. School officials have made efforts to engage the child, parent, or person legally responsible. And no parent or person legally responsible has taken any action to rectify the situation. When talking with children, please find a private place. Remain calm. Be honest, open, upfront, and supportive. Be an advocate for the child and listen to the child and report the situation immediately. Please remember, when dealing with child abuse or maltreatment, you are not to investigate or interrogate. Your responsibility is to access information for a reasonable cause to suspect and make the necessary report. Occasionally, you learn of possible abuse or maltreatment not by what you see, but by what the child says. When a child discloses, consider the suggestions or do's for talking with children. When talking with a child, stress that the situation and the behaviors are not their fault. You are not legally required to inform parents or other persons legally responsible for the child's care that you are making a report to the SCR. Do not assume a parent will support the child. If you have questions or concerns about whether to inform parents, contact your local CPS. Informing the parent or other person legally responsible may place the child at further risk or harm. Whenever we're talking to children, always remember, don't overreact. Don't make judgments or promises. And remember, it is not your job to interrogate or investigate. There are specific guidelines that apply to cases of suspected sexual abuse. Once a child reveals information that makes you suspect sexual abuse, avoid talking in detail with the child about the incident. Often, CPS and law enforcement work together to interview a child at the same time. These professionals have been specifically trained in interviewing children. This is a traumatic experience for a child to relive. In your role as a mandated reporter, try to minimize how much you talk to a child about an incident involving suspected child abuse. People that can be reported for suspected child abuse and maltreatment include the parent, the guardian, a custodian, a daycare provider, or a residential care staff. These are people considered legally responsible for the care of the child. Knowing who has caused harm to a child is a significant factor in determining how to proceed. The SCR only registers reports against a parent, guardian, or other persons 18 years of age or older who are legally responsible for the child. According to the Family Court Act, persons legally responsible include the child's custodian, guardian, and any other person 18 years old or older responsible for the child's care at the relevant time. This includes any person continually or at regular intervals found in the same household as the child when the conduct of such person causes or contributes to the abuse or maltreatment of the child. Once the SCR registers a report, the person who is named as causing the harm to the child becomes the subject of the report. Additional information and definitions regarding the subject of the report can be found in Social Service Law Section 412. Teachers in most public and private schools do not qualify as subjects of reports when they are acting as teachers. Teachers can be subjects of reports when the incident involves their own child or with a child they have legal responsibility for outside of their role as a teacher. Imminent danger can be considered the distance between the child and the harm by the actions or failure to act. Imminent danger could occur immediately or very soon. Imminent danger is a direct threat to a child. Imminent danger is a term that measures the distance between a child and the harm created by a parent's or other person's legally responsible actions or failure to act. Imminent danger means that the child is placed at immediate risk or substantial risk of harm. The key factor in assessing imminent danger is to ask yourself, how direct is the threat to the child? In other words, the danger to the child must be immediate or nearly immediate. The standard to be applied is reasonableness. Ask yourself, is it reasonable to believe an intervening factor could occur? If the answer is yes, then there is no imminent danger. If the answer is no, then there is a reasonableness to assume that harm could occur and there is imminent danger. An example may help clarify this point. If a parent swings an object at a child attempting to strike the child on the head but misses, we can say that the danger was imminent. The only additional factor necessary for the child to be injured was for the parent to connect rather than miss, and it is reasonable to believe that this could have occurred.